So the Appellate Division 4th Department, hear ye, hear ye, hear ye. All persons having business to do this work should draw near to their attendants, and they shall be heard.
Oh, sorry. Good morning. Please be seated. The first case for oral argument this morning is number 622, People versus Reggie Caswell.
Morning, Honors. Police and Court, Paul Watkins, representing the defendant appellant Reggie Caswell. This is a case where it's conceded my client was never provided with a copy of the second felony information that the people were using to have him found to be a second felony offender. He has absolute right to see that. If the people are going to contend he's a second felony offender, he has a right to see the statement, to see exactly what is on that statement and what they're contending with other felonies. This is especially important in this case because if people are contending you've already been found to be a persistent felony offender. And if they're going to use that prior finding, they need to present both that prior finding and the second felony information so my client can review those and determine if in fact what they're alleging for the second felony offender is related to what was earlier found a persistent felony offender. They never did that.
Well, you understand, I'm sure, that this makes no difference to your client. He got concurrent time. He got, if it gets vacated, it gets sent back. It really makes no difference to him. He's already a persistent felony offender. Whether he's adjudicated a second felony offender or not doesn't seem to help him out a great deal.
Well, I understand that part. But the problem is that assumes he's a second felony offender. If you're right, if he's been found to be a second felony offender, the sentence that was imposed, which is concurrent, is the best he's going to do. And I understand that. But that assumes he's found to be a second felony offender.
I'm saying, let's assume that he's not. Let's assume that the court says, okay, I'll just sentence him as a first-time felony offender. He doesn't save him any time in prison.
Well, Your Honor, I understand that. But at the same time, my client does have the right to go forward with his appeal. He does have the right to see the second felony offender information. And I understand all that, Your Honor. But at the same time, my client is adamant. He wanted to go forward with the appeal. And if the people are going to see is going to contain the second felony offender, he needs to have that information in front of him so he can look at it.
I think we have that argument.
Thank you, Your Honor. Next point is about the PSI. It's clear that there's never a PSI that was ordered by the court, and it's clear from the record the court never even considered a PSI.
Mr. Watkins, he was incarcerated during the entire time.
That's correct, Your Honor.
Okay.
But at the same time, I understand what the point is, that the prior PSI would have been sufficient. But the problem is the court never even mentioned the prior PSI. Never even mentioned that it was reviewing any PSI. As far as we know, it didn't even have a PSI in front of it. And that should have been done. So I would contend that both of those points, no second felony offender information, no PSI, means that the matter should be remitted to the court. If there's any questions, I'll submit. Thank you.
623, People versus Patrick Ponzo.
Good morning, Your Honors. May it please the Court, Catherine Friedman, representing Defendant Appellant Patrick Ponzo. Your Honors, the record and the testimony in particular in this case is quite extraordinary. And so I thought that I would start with what I consider to be the cleanest issue among the issues that I raised in my brief, and that is that the trial court abused its discretion when it failed to consider my client's pro se motion for new counsel. I think this court's decision in People v. Robinson is clear that the court must make some minimal inquiry into the defendant's allegations.
And counsel, do they have to make an inquiry if they don't, what the defendant is saying has no merit or is not serious? I mean, doesn't there some type of a bar set?
There is a threshold, Your Honor, you're absolutely right, but in this case, my client outlined 9 distinct arguments, some of which I submit had some serious credibility to them.
Like which
And,
ones?
In
Which
particular, his second argument, indicating that the wrong crime was mentioned in the one
Well,
of.
there's no question that the paperwork mentioned arson, but doesn't that sometimes occur where paperwork isn't corrected? Everything else in the motion was appropriate to the case, wasn't it?
That may sometimes occur, Your Honor, but it's our contention that the court, that's a serious allegation, and the court owed it under your precedent, under People v. Robinson, to consider it. And if the court found that that wasn't serious, that's fine.
Was there
But-
any valid motion that you think should have been made that was not made? That was just an obvious typo, or the lawyer used a prior motion, failed to change the language there, referring to fire. But is there any of his allegations, any of the other ones, have merit? In other words, pointing out, you should have done this?
Yes, Your Honor.
Like
In
what?
particular, his third point regarding the Mapp and Clayton hearing, and overall, generally, he
Right, but
points.
what was, under the map, what should have been moved to be suppressed?
Well, that the hearing should have been held.
But what evidence do you think should have been subject of a hearing?
That's a good question, Your
Yeah,
Honor.
I think it is, actually.
That's a very good question, but
I think
generally,
what he was talking about is the gun
yes,
that was found on the side of the road,
yes.
that was abandoned, not on him, not in his car, not in his house.
Mm-hmm.
And he seems to think that should have been suppressed somehow when he allegedly, somebody threw it on the side of the road.
Somebody threw the
Is
gun
that
on
a
the side of the
valid
road.
motion to suppress?
So I do think that that is a significant issue that the court could have reviewed. And again, if it found it to, rise to the level of ineffective assistance, great, if not great. But my client wasn't given that opportunity. And again, generally, my client brought up a number of instances where there was no communication or a breakdown in communication between counsel and him.
We'll
And
look at all those issues
Okay.
very carefully.
All right, great, thank you, Your Honor. And just very briefly, with regard to my other contentions, the probable cause hearing, very convoluted, what happened there. It's our contention that defense counsel attempted to show that my client's detention was unlawful, and that was cut short by the court. And under People v. Misuis, I believe I'm pronouncing that correctly, that he should have been afforded the opportunity to cross-examine the Trooper Hunter with regard to whether or not my client was properly detained. The court essentially didn't allow any follow-up, didn't overrule the objection made by the prosecutor, and we submit that that's error. If this court finds that that wasn't, then on the other hand, I
So
think
what should be suppressed if there's an error there?
if there was error, there was no probable cause to arrest him.
Right, but what evidence should be suppressed as a result of the unlawful arrest?
His statements, his statements to
The
the,
few exculpatory statements he made to Trooper Hunter in the house.
yes. Yes.
I think we have that argument as well. Do you have anything further?
Wrapping up with regard to legal sufficiency and weight of the evidence, the prosecutor's main witness, Your Honor, had some serious credibility problems. I think we have to take into account that by her own admission that evening, she was under the influence of cocaine, crack, meth, Molly, and a number of other substances.
And
How
often
she could,
that's a story for witnesses.
I'm sorry?
Often that's a story for witnesses.
And the fact that, I just find that it's inconceivable that she would be able to remember anything from that evening. So that, in conjunction with the fact that she cut a deal with the prosecutor, in conjunction with some of the other testimony that was inconsistent, we submit,
Wasn't her testimony corroborated, though, by other witnesses and physical evidence that was found on the roadside?
I would say that some of that other testimony, Your Honor, also was contradictory. I think that, Mr. Ritchie, excuse me, he made contradictory statements. I would actually submit that it's really not clear what went down that night. It's quite convoluted. So with that, if you have any other questions?
Thank you.
All right, thank you.
Good morning, Your Honors. Morgan Mayer on behalf of the people. I would just like to address counsel's last point about the credibility very briefly. That is a question for the jury to decide. In the testimony, all of that was brought out. Her severe substance abuse problems, her lies, her deal with the prosecutor. And they heard that and they made their decision. And like Justice Winslow said, it was all corroborated by other evidence.
Including the defendant's DNA on the firearm that was found on the side of the road.
Correct, as well as that hoodie, and they had a match from the cup that he might not have drank out of, like counsel suggested, but he did hold it at least. We have testimony that will leave DNA, so we have a valid DNA source pointing the defendant there. We have evidence that they were at McDonald's, they were at the gas station, they were at Megan Payne's apartment, they were at the scene of the crime. And based on that, I think the jury had enough evidence to make a credible decision. And if there's no further questions, we'd submit on the brief otherwise.
Thank you very
Thank you.
People versus Rashad Costin.
Good morning, Your Honors. Phil Rothschild from Hiscock Legal Aid on behalf of Mr. Costin. First point I'd like to address briefly is the plea in this case was not knowing, voluntary, and intelligent. Mr. Costin made some very ambiguous statements that the court really should have further followed up upon, basically to make a record for this court to review. When asked if he was going to plead guilty, he said, "You were going through the plea allocution, so I plead guilty." So I believe that's what's stipulated here. I understand, it could be viewed as some type of gamesmanship, but it was really up to the court to engage in further inquiry regarding this. Regarding the threats, which I believe Mr. Costin outlined in his pro se motion, he was threatened with a longer sentence if he proceeded to trial.
I don't believe he was threatened with a longer sentence. He was suggested that it could happen, but it wasn't, like in most of the cases when it's been an actual threat saying, well, if you go to trial, this is what you're going to get. That wasn't how this was phrased.
Well, Your Honor, it's always an ad hoc determination by this court, essentially. What was said here is, I don't want to be sending you to jail on this thing. If you happen to lose a trial, you're most likely going to state prison. He also said the offer was going to be off the table the further along we get.
But wasn't that said in the context of you'll be sitting there saying, why didn't I take probation?
Exactly, Your Honor. And so you're going to be sitting in jail saying, why did I not take probation?
And I think that's my colleague's argument, is that a lot of the cases you cited to, and you're correct, it was, you are going. I mean, it was a definitive. And this one leaves the possibility that you may go, more likely to go, but it's not as if you're going to go. But I understand the argument. It is troublesome to take a look and read that it wasn't used to kind of coerce a plea.
Yes, Your Honor. But what distinguishes this from other cases is the fact that Mr. Costin did make a motion to withdraw the plea, which separates it from...
Do you have any cases, because this isn't I'm definitely going to send you to prison. This is there's a strong possibility you'll end up in state prison, and he also said it's most likely you're going to state prison. Well, so are there cases... Because I tend to think that any person hearing that is going to think, I'm going to state prison. When the court says strong possibility and most likely, but are there cases similar in language that was not unequivocal, this is what's going to happen, or this is what's most likely going to happen? Do you have any cases along those lines?
Your Honor, I would just point to the fact that even in cases, case I argued earlier this year, where this court said this was one of the worst plea allocution, one of the worst threats I've ever seen, it's really an ad hoc determination depending upon all factors. And in this case, a person could look at it and say, well, this is troublesome. Was there the direct threat? I don't have any cases per se where there was less than that, but I do believe that the totality of the factors is something that should have been considered by the court. And I think what we really need to look to is the fact that I believe that this court really wanted to rush things along. And I understand there was a 3-month where he kept on saying, do this, do this, do this. But all along he was saying, you got to do this, because if you don't, you're going to be going to jail.
Well, I don't think he quite said that, but.
Not quite, but it was in that nature. But I think what really separates this from the other cases is the fact that there was a motion to withdraw. And I believe that comes to the second point regarding defense counsel's actions in this.
Well, the defense counsel didn't say anything until after the decision had already been made. And that's when the defense counsel opened his mouth.
Well, Your Honor, I would submit that prior to the, right after the plea, defense counsel said Mr. Costin told me he wanted to withdraw the plea. Defense counsel said he was not going to join in that motion. That's fine. I mean, defense counsel is absolutely entitled to do that. Defense counsel is also entitled to explain his actions when questioned by the court. Like, what did you do here? In this case, defense counsel volunteered, at sentencing that he opposed the motion. He contended he was not ineffective, adequately reviewed the plea, and he intimated that Mr. Costin understood it perfectly.
Was the motion denied before defense counsel allegedly took a position?
Well, Your Honor, I think that the motion may have been denied, but I think in that situation, it really was incumbent upon the court, once the defense counsel had said this, to appoint new counsel.
See, that's the problem we have, Justice Smith pointed out, is that if he made a decision before he heard any of this information, does that scenario change as opposed to him saying it before the court makes a decision? That's what we're trying to pocket it into.
I mean, the question is, were defense counsel's comments gratuitous, essentially?
Meaning that it was
It
after.
already happened.
I would submit that it wasn't, because the decision really, it's like, it was really up to the court. The court said, okay, boom, that's it. There's no backsies on this thing. But the reality is, they were still proceeding with the sentencing, and the defendant was still objecting. And in those situations, first of all, I don't believe the defense counsel should have volunteered. And secondly, I also submit that
It might not have been the best avenue. I
Yeah.
don't disagree with that,
And-
but under these circumstances, I believe that wasn't offered until after everything was done.
Well, I would submit the safer course of conduct would have been for, in that situation where defense counsel does do that, to assign new counsel to further explore what's going on.
Thank you.
Thank you.
Good morning. May it please the court, Caitlin Guptill on behalf of the people. To begin, I believe that the defendant's plea was knowing, intelligent, and voluntarily entered. I disagree with Mr. Rothschild. I believe that the court did conduct an inquiry into defendant's expression of confusion, specifically as it pertains to criminal possession of a forged instrument in the second degree. I do believe that, to comment on Justice Lindley's position, the cases cited by the defense, Flynn, Fanini, and Williams, all indicate a definitive term of a sentence.
In your view, as long as the court doesn't make it definitive, the court could say, you're very, very likely to go to state prison, or it's a really strong possibility here you're going to prison, or it's almost certain you're going to prison. Is that okay? Is that coercive or not?
I think that coercion needs to be reviewed in a totality. And under these facts here, in an evaluation of the totality, I think that he was afforded efficient time, over 3 months, to consider the probationary offer, and actually the defendant's sentence got better at every appearance.
Well, do you think a reasonable person in the defendant's position, when the court says there's a strong possibility you'll end up in prison if you go to trial and lose, you're most likely going to go to state prison if you lose, those are the two things. A reasonable person hearing that would believe that if he lost the trial, he or she lost the trial, he or she is going to prison.
I think that a reasonable person should be advised of the potential sentencing exposure that they're facing to move forward. And I think in an evaluation of the totality, a reasonable...
To answer the question, do you think a reasonable person would assume they're going to prison if they lose trial in that situation?
I don't. I think based on the totality of this judge and this judge's treatment of this defendant throughout the entire case, I don't think in these circumstances a reasonable person would automatically assume that they were going to state prison if they chose to go to trial. If there's no other questions, I'll rely on my papers. Thank you.
People versus Randy Howard.
Good morning, Your Honors. I'd like to begin with my argument that Mr. Howard's motion papers raised factual disputes that required a hearing for resolution of the suppression claim, and that it was error for Supreme Court to summarily deny his motion to suppress without a hearing.
What's the remedy for that error? Since you started there, what's the remedy according to your proposal here for that particular error?
Your Honor, there needs to be a remittal back down to Supreme Court in order for a hearing on the motions to suppress and in order for a determination about whether suppression is merited or not. And there's kind of two issues here, two factual disputes that I think are raised by the motion papers. One is whether there's probable cause for an arrest, and the other is whether there was law enforcement compliance with CPL 140-15 subsection 2, which requires our law enforcement officers to inform somebody of the reason for their arrest when they're not arrested contemporaneously with the commission of a crime.
Wasn't there another issue that was raised by Mr. Young in his defense paper, in his motion papers? He raised Peyton as an issue. He raised probable cause. You didn't have probable cause to arrest me, which is separate from you arrested me in my house without a warrant. And it sounded like Justice Renzi dealt with the Peyton issue, said there was a search warrant, so therefore there's no Peyton violation. Your argument is that's all irrelevant to the probable cause. The fact that there's a search warrant may excuse any Peyton violation.
That's correct, Your Honor.
But it doesn't cure, the mere fact that there was probable cause to search his house where he lived with his mother doesn't mean there's probable cause to place him under arrest.
Correct.
So the court's ruling to deny him a PC hearing was on the assumption that he was only moving under Peyton.
That's correct. And, you know, when you look at this section of the defendant's omnibus motion, he does cite to Peyton, and I think that's confusing. But when you read those paragraphs, paragraphs 31 to 34 of the omnibus motion, he's not alleging a Peyton violation. I think that citation to Peyton is some boilerplate language that may have been left in that motion, and it clearly confused the people, it confused the court.
Counsel, how do you address the people's position that what's contained in the motion is insufficient for the raises 140-15-2, that there's it doesn't warrant a hearing because the information doesn't rise to that level to have them?
So I think there's two things there. One is, are there sworn to facts that establish something that could be a legal claim, and is that legal claim a claim that would lead to suppression? And what we have is Mr. Howard's own affidavit in this case, in which it says he's arrested immediately when the law enforcement enter his house or his mother's house to execute the search warrant, and he's immediately taken to the car and taken to the public safety building. So we've got no notification. Those facts are there. And I think the people's position on appeal, as I read their brief, is that that is not a legal basis for suppression. And I am aware of no cases that hold that violation of CPL 140-15 subsection 2 categorically does not lead to suppression. And I think in this case, this is exactly the case where suppression of the fruits of an arrest, and in this case, this is the statements Mr. Howard made before he invoked his right to an attorney. This is exactly the case where suppression is deserved. Because when you look at hearing exhibit 4, which is the recording of the interrogation at the public safety building, the investigators and Mr. Howard are chatting about a number of homicides that have taken place. They're chatting for about 15 minutes about these various homicides. And then the moment that Mr. Howard kind of figures out that he's being accused of shooting Mr. Stevens, he immediately invokes his right to an attorney. And I think the facts of this case show that had he known from the moment of his arrest why he was being arrested and being accused of a murder, he would not have spoken to the investigators, because the moment he finds out why he's being arrested and what they're talking to him about, that's when he invokes his right to an attorney.
Right. Wouldn't the answer to Justice Center's question be that under Concepcion and LaFontaine, we can affirm only on the basis of the same ground that Judge Renzi ruled on? In other words, Judge Renzi said, I'm denying you a probable cause hearing because there's a search warrant. We can't look for some other reason to deny the motion without a hearing.
That's correct, Justice Lindley, but this court could grant that motion or remit for further proceedings. Basically, okay, Supreme Court did not reach this issue. We need to remit because this was an issue raised by the defendant.
So that's what you're really asking for, is a remittal in this case?
That's correct. There should be a remittal and there should be a hearing to determine whether there was probable cause for arrest and whether law enforcement complied with CPL 14015, and if not, whether suppression of these statements are warranted.
I thought his question was whether the motion papers, the allegations that your client made were sufficient under Mendoza to warrant a hearing. I thought that's what the people's argument was.
And I think those allegations are sufficient to warrant a hearing.
Right, but even if they're not, my point is that Renzi didn't deny it on that basis. So we can't affirm on that basis.
That is correct. Concepcion and LaFontaine would bar this court from affirming on the basis that there are insufficiently sworn facts in the omnibus motion.
Thank you.
Counsel, let me take you to the waiver of appeal issue real quick.
Absolutely.
Even though the law hasn't changed, apparently some would argue it has, but in any event, looking at the transcript of the plea, and then I know there's a written waiver somewhere in the appendix of the record, but there's no mention of the written waiver, to my observation, in the plea colloquy. So my question ultimately boils down to, you know, we have cases that say that we can't consider the written to help the oral when the written hasn't been, the court didn't extract a comment from the defendant, have you read it and do you understand it? So therefore the written can't help the people preserve the oral. Here we have sort of the reverse. Why is it that the written, according to your argument, is even relevant to the oral when there's no mention of it whatsoever that it was read or understood by the defendant? That's my long question.
So that's a great question, and it is true that the written waiver of appeal is not addressed before or during the moment when the oral waiver of appeal is taken, but at the very end of the plea proceeding. It's the last words spoken on the transcript. I believe it is either the judge or it is the defendant's attorney who says, okay, yeah, we're going to take a look at this written waiver appeal and we're going to get it signed. So this happens after the oral waiver, that the written waiver is reviewed and signed. But on the record, the judge does not inquire, have you had time to read this with your attorney? Have you reviewed it?
I guess that's the point of the question. If the judge doesn't ask, did you read it? Is this your signature? Do you understand it? Any questions to your lawyer? Without that, how does that even come into play with written?
You know,
Because we don't, I mean, I guess one of the arguments is twofold. One of the facts is how do we even know he read it? And the other fact is I believe it said he signed it. So do we assume that when he signed it, he read it? I mean, that's why I guess the question is, where does the written fall into the gambit here?
So, you know, we contend that the written waiver is invalid, but even if you say just look at the oral waiver of appeal, if you subtract the written waiver from your consideration entirely, I think we still have an overbroad oral waiver in this case. It is, again, I think the judge's language, both at the plea proceeding and then again at sentencing, where he's saying you don't have an appeal, no appeal exists here. I think you do need to look at the totality of those circumstances, including the court's comments at sentencing. But when the court's treatment of the waiver during the plea proceeding is fairly brief. He says, you know, the appellate division could review my motions, my decisions, everything that's happened in this case. For all intents and purposes, when I sentence you, it's going to be final. He does note that some issues are accepted from it. But he's talking about it in a pretty complete way. And then again, I think we need to look at those comments at sentencing where he says, I'm not gonna expedite any appeal that doesn't exist, and referring to basically no appeal for Mr. Howard.
Would you agree that in this record, the written waiver is irrelevant to our analysis?
Your Honor, I don't think the written waiver is irrelevant. It is mentioned in the plea colloquy, and I think it is overbroad. Mr. Howard's signature is on that form, so I think it is relevant. It is part of our record. It was filed with the court, and it's overbroad in two different ways.
But to have it count or mean anything, we'd have to presume, as Justice Central was alluding to, we'd have to presume that your client read it and understood it, even though we have case law that says we don't consider the written when the court hasn't said, oh, you've read it and you understood it. So is part of your argument a relevancy of the written waiver that we must presume that your client read and understood the written?
Your Honor, you know, I didn't address this in my brief, and I guess my position to the court would be that whether you consider the written waiver or not, I do believe that the waiver is invalid.
Wouldn't your position also be that the defendant signed it as part of the record? For us to ignore the written waiver, which is overbroad, I think everyone agrees it's a bad written waiver. For us to ignore that and act like it didn't exist, we have to presume that the defendant did not read it and did not understand it. We would have to assume that. And there's no basis to assume that he didn't understand what he signed. So that's, for us to ignore it, we would have to assume he had no idea what he signed. That's a pretty big assumption.
I think that's correct, and I perhaps, to answer Justice Curran's question as well, perhaps less weight should be given to this written waiver. The record indicates that he was going to sign it. It is mentioned at the end of the plea colloquy, but we don't know that he read it and understood it or had time to discuss it with his attorney. So the written waiver is part of our record, but we don't know to what extent the defendant understood it. I think it might be wrong to presume that he fully understood it, and it may be wrong to presume that he didn't read it or didn't understand it at all.
There's a burden here. When somebody's waiving their right to an appeal, there's a burden here that has to be clear, and it's not on the defendant.
And I think this record is unclear as to whether this was a knowing and voluntary waiver. And I would say particularly when you're looking at that written waiver, it's overbroad as to waiving the right to a counsel and the right to poor person relief on appeal, and it's overbroad as that it purports
But
to waive.
You understand the conceptual problem that we're going back and forth here on a little bit, is that if we presume that the defendant read it and understood it, that's going to help the people in the long run, and probably in a lot of ways. So as long as there's a written waiver on the record, it could be damaging to defendants in the future. So you don't want to say it's presumed, and yet if you say it's not presumed, it's really not relevant. So that's what I'm sorting out, and forgive me for going on about it, but I haven't figured it out yet.
I would just submit to the court that there cannot be a presumption either way based upon this particular record. And if there's no further questions, I'd rest. Thank you.
Good morning. The people took the position with regard to the suppression issue that the issue of probable cause or a patent violation is resolved when you look at the warrant and the warrant affidavit, which in this case set up both probable cause to believe that the defendant and his co-defendant committed the crime. That's identified in paragraph 23 of the affidavit, where the investigator LaFaso says, based on all these facts that I've already alleged, there's probable cause to believe that both of these individuals are involved in the murder.
Right, and I agree with you on that. I read his entire affidavit. I think if it gets remitted, your office will probably win on probable cause, based on the evidence set forth by the investigator. But Judge Renzi didn't rule that way. He didn't say, I've looked at the allegations in the investigator's affidavit for the application for the search warrant, and there's probable cause to believe the defendant committed a crime. He just said, I'm not granting you a hearing because there's a search warrant. And that would you agree on that basis that was not a proper basis to deny a hearing, the mere fact that there's a search warrant when the issue is probable cause to arrest?
In this case, yes, because there was probable cause in this case not to believe that they committed the crime, but that the evidence would be found there. And the warrant itself specifically says, I think it's the second to last paragraph of the warrant signed by Justice Argento. She says, when you take the defendants into custody. And I guess what I'm struck by the fact is that there's no reference to Keones or Dennis in this case, in which this court
Those were patent cases, I think.
And there was patent, but there was also, the language was, my recollection was, there's no need to get an arrest warrant when the search warrant has met that higher standard. And in this case, I guess I would question, what would the probable cause wouldn't be? The defendant in this case got more traction by the court having a Darden hearing than had the court had a probable cause hearing.
Right, now, let me just add one thing about Quinones. We said, and I was on that case, we said, we note the defendant explicitly concedes the validity of the search warrant, and he does not dispute that the police had probable cause to arrest him. And that's why I think, the defendant here does dispute probable cause. But I understand your point. If you look underneath the hood of the search warrant and the application, I think there could be a basis to deny the defendant a hearing on probable cause. But you would agree that the mere fact in general that there's a search warrant doesn't necessarily mean that there's probable cause to arrest.
Not every search warrant.
Right, not every search warrant. So we would have to know that Renzi looked underneath and said the allegations in the application for the warrant established probable cause to arrest. He didn't say that, though.
This is what I think perhaps maybe there's a difference. And I believe the court's being hung up on the judge's reference to the patent claim. I think, the motion papers were very bare-boned in this case. And this is how he captioned his title. warrant arrest / Peyton violation.
Yep.
I think the judge just made reference to the Peyton violation.
Right, but
I
if
mean,
you
the
read the
people
subsequent paragraph, it makes it very clear he's arguing no probable cause for the arrest.
And I think it's equally clear that this case was all turning on Dennis and Quiones, that the underlying affidavit can be sufficient. And I think that Judge Renzi was actually the judge on Quiones. And I think this judge was well aware of the fact that there's no probable cause issue if the search warrant application is sufficient. And I want to stress on appeal, defendant doesn't even challenge the sufficiency of the search warrant on appeal. That's not even an issue. So if Justice Argento found there to be probable cause to support taking the defendant into custody and the search warrant, Judge Renzi reviewed the warrant, found the warrant to be sufficient based on the four corners, and then even went the extra step and had a Darden hearing. I don't think that there's really a probable cause issue here. And I'm not sure if I finished my thought, but a probable cause hearing, you would have the investigator coming in and just testifying as to what the informants told him. Here, there was a Darden hearing. Defendant got an opportunity to ask questions. The actual informant, was called to testify. I believe the defendant got much more traction in the manner in which it's handled it. I would hate to see this court base its decision just on the reference the judge made to a Peyton violation when the underlying arguments here were all based on Dennis and Quiones, that if you look at the affidavit, that's what the people relied on. Defendant made reference to the fact that, I didn't get discovery. And they're like, no, it's in the affidavit. We gave you the affidavit. They attached the affidavit to the motion papers. So I think that if you look at everything, that's clearly what Judge Renzi did in this case. He was well familiar with this court's law.
That's not what he said he did, though. That's the problem. He didn't say he did any of these things that you're saying. He just said there's no Peyton violation, there's a search warrant. I'm denying your motion.
He said, as to the Peyton issue,
right.
I've looked at the warrant, it's fine.
Right. So he never addressed probable cause is my problem here.
I would just say that the underlying body of it, but I believe that he probably looked down at the headings and as he addressed the decision.
But that doesn't help.
And then I also asked the court to consider the effect of the Darden hearing. Did that establish probable cause?
Well, I'm not coming up with the name of the case, but I thought there's a case from the Court of Appeals that cites to La Fontaine and Concepcion in a footnote and kind of creates a little bit of if it's within the parameters of the motion papers. I may have that wrong, but so we got to look at whether or not we're precluded under La Fontaine and Concepcion. I'm just not sure if you can come up with the name of that case off the top of your head. Probably not.
And Robin, could you give me a little bit more facts?
No. No, I wish I could. I'm sorry. I went down that path. When you get a chance, I'd like to talk to you about the waiver of appeal whenever you're finished with your other
I do. And I guess, like I said, I just think that if you look at the underlying argument on this is all about Dennis and Quiones. And that, yes, the judge made reference to the Peyton heading, which defendant put on his motion papers. But I think it's clear he's addressing probable cause. And, there is nothing else to have. I mean...
Why don't we go into the waiver of appeal?
The waiver of appeal. Clearly,
Here's my question. I mean, it doesn't take a lot to run a judge's name and waiver / same sentence appeal. And you come up with all the waiver appeal cases we have having to do with any particular judge. So if you look at that, you'll find there's 3 instances, including one today, the first one on today, where your office has conceded that the waiver of appeal by this judge was wrong, was incorrect under Thomas. And then we have others where we've assumed that the waiver was invalid, assumed arguendo. So here, why is it in the one, maybe you weren't the ADA in the one, the first one today, but why is it sometimes your office is conceding that this judge's waiver appeal is invalid under Thomas, and sometimes it's arguing it out, such as here?
Because of what's said on the record. And I think a lot becomes in this case, in this situation, where the judge...
You don't think judges typically do the same thing time in and time out?
Not this case. This case definitely had some twists and turns to it.
How is this different than the case Ms. Porter had this morning? I think that the written waivers, I compared to written waivers, and they have the same overbroad language, but your argument is that the bad written waiver was cured by the oral waiver.
By the oral language of the court clarifying.
Right. Yeah, the court's oral waiver.
Colloquy.
Yeah. How is it different than the colloquy? I mean, this is probably unfair because it's not even your case, but we have one, as Justice Curran said, the first case in the docket, Judge Renzi, same problem with a written waiver. your office concedes that that was bad, so there must be something different that was said by Judge Renzi during the oral colloquy.
So the written waiver, the caption talks about you're waiving your right to bring post-conviction challenges.
Yeah.
In this case, you've got what he says, it's prior to imposition of sentence. Now, one thing I could not find any case law on is specifically whether or not you can consider what the judge says at sentencing. But what I did find is a case law out of this court where you talk about the totality of the circumstances when evaluating the waiver of appeal. And I'm assuming, unlike the case you heard this morning, you didn't have a situation where the judge specifically said, look, these reasons why you're challenging your waiver of appeal should be brought pursuant to a CPL 440 motion, which I will entertain. So for that reason, I don't think any ADA can get up here and say every written waiver is I'm not saying the written waiver was correct here. So to that extent, I'm sure I'm consistent with the first case.
But do we even consider it, since the court at the time of the plea didn't even mention it as far as I can?
Absolutely, and I wish I could take credit for coming up with that, Justice Kerman. Yes.
Well, I don't want to make arguments for either side.
No.
I can't
So
avoid the fact that's what the record says, or doesn't say.
No, it's correct. And I know
Your position is it can't be used as a shield and a sword.
exactly. And Justice Lindley, you're saying, how can we assume that he didn't read it, or that he didn't read it or didn't understand it? How can we assume that he did read it or didn't understand it?
There's a burden here when somebody's waiving a right that I don't think it's inconsistent to require the court, if you're going to rely on a waiver to deprive someone of their right to appeal, to make sure that the defendant understood the nature of the waiver. Here, what we'd be presuming is that the defendant signed it. We're just going to ignore it because there's no indication on the record that he read it. But he did sign it, so I don't know. I just think that it's not...
I think it's more than just no proof that he read it. There's no proof that he understood it, or that what he was told by his attorney about it. We would definitely, I believe that if the opposite were the case, I think that defendant would get the benefit of any assumption.
I agree.
Can't the people also waive the waiver? It's something that you got as part of the deal, so to speak. Can't you simply waive the waiver, such as when you concede that it's invalid, and you don't want to fight about it? You could just waive it, couldn't you?
I don't know if I can if the waiver gives him bad information. You know what I mean? Like, if the defendant signs a waiver that says you can't bring post-conviction challenges, and there's nothing said by the judge, I don't think I can waive that.
So, but then do we even count it when the judge hasn't even said, have you read it and understood it? So, how does that factor in?
We're gonna look at all this very, very carefully as you can.
Understood.
Thank you, Your Honor.
As you can read, and thank you for answering all those questions. Bankers Healthcare Group LLC versus Unreal Husenbol.
She's a veteran.
Good morning. May it please the court, Lee Alcott, Barclay Damon Syracuse, on behalf of the appellant, Bankers Healthcare Group, or BHG. The question at issue in this matter is whether the New York court should have effectively transformed itself into a Florida court, operating under the Florida Rules of Civil Procedure and ruling on the motion for summary judgment. And I would add that this is the only time in my career where I made a motion for summary judgment that was unopposed, lost, made another motion for summary judgment that was unopposed, and lost again.
And he did what he said the second time, what he said the first time to do.
Essentially. The New York court could not do that. It had to follow the CPLR.
Well, you've got a little bit of a conflict here, don't you? It says that the agreements will be governed by the procedural law of Florida. That's kind of odd. I understand how it says substantive, but then it says you can venue it in Onondaga.
Correct.
You can't venue it in Onondaga unless you apply the CPLR, right?
Correct.
I mean, we apply procedural rules under whatever it is, Erie, whatever it is.
Wherever the court is, those are the rules that
Law school
apply.
days, right? So
Sorry.
I guess the reference to procedural law could be, for example, I know that Florida follows the federal rules of civil procedure in its procedure.
Correct.
So it could be that there's no 3213 motion, for example.
Right.
So we could reconcile it that way. But no matter what here, you're saying the court made an error.
Yes. And what the court actually asked us to do is what we did. It said, identify which of the Florida rules of civil procedure would apply here. So we did that. We filed another affidavit. We cited the Florida rules. Not surprisingly, they're remarkably similar, if not identical, to the New York rules. But the underlying premise here, we had to go back to a case in 1936, the Mertz case that we cited, to find the holding that the law of the forum controls the law of the case, and that is the CPLR. The CPLR applies in all instances where a case is brought in New York.
Thank you.
Thank you.
Elena Spivak Bobco versus Gregory Arms LLC.
Morning, Your Honors. Brian Biggie on behalf of the appellant. I think the question presented here is whether this plaintiff is required to show notice like any other plaintiff asserting a common law negligence claim. I would submit that
Why, if your client had exclusive control over the heater and the thermometer setting, isn't there an inference on a res ipsa that your client created the defect here?
There's two issues with respect to res ipsa here. First, the trial court assigned 10% of comparative negligence to the plaintiff herself. That would preclude an analysis under res ipsa.
What case says that, sir? I think if you look at the PJI, you'll find that there's a number of cases cited for the proposition that comparative fault did not negate res ipsa loquitur when there's comparative fault for the plaintiff.
But, Your Honor, I would submit...
And if you do have a case, I'm listening because I may have misread it.
Off the top of my head, I don't, Your Honor, but I will certainly try to submit one after oral argument. But I would submit nonetheless that the intent was certainly to secure the boiler system. But the suggestion that it was just wholly and completely within our control, I think, overstates the record. This is not a fob door where we can track...
But when you say it overstates the record, that goes to the weight. And we're looking at, that's a pretty deferential statement for any finder of fact, court or jury, right? So it's not where the court couldn't find exclusive control, correct?
I would argue I would argue that finding exclusive control would be an unreasonable conclusion based on the record.
Why is that?
Because again, as I was saying, this isn't Fort Knox. This is a plywood door.
But they've indicated there's a door, there's a lock, they keep it under lock and key. There's no testimony that this woman had a key or entered the room whatsoever.
No, but
And the only people that had access to it are the people that either he hires for maintenance or the maintenance person in the building.
And again, Kevin Keating, the main HVAC guy, conceded in his testimony that it's certainly possible the door could have been left unlocked. West, the owner, testified that these keys are changed out as...
What would be the purpose of them locking the door? Is to keep people out.
Correct.
And they're fair to do that. Okay, and that's where the right to have a key. They specifically have a key to keep the door locked, to keep people out, and for this to happen.
That is the intent, but I don't think the testimony establishes that was successful.
Hey, look, I think you make a lot about lack of notice, constructive notice, actual notice and all that. I think that would carry more weight if the hot water tank had malfunctioned, and that caused the scalding here. But it seems undisputed that somebody set the thermometer on that hot water tank at 150 degrees. It was set. It didn't malfunction. It was set lower, and then something went wrong, and it just overheated. Somebody set it at 150, correct? And it was a locked room. If it was your client or one of his employees, then he's liable, correct? If they are the ones who set it at 150.
Correct.
Would you agree with that? Right. So the only way you win is on some theory that, well, even though it was locked, maybe somebody else somehow got in there and for reasons unknown set it to 150. That's how you win, but there's no evidence of any of that.
But at the same time, Your Honor, there's no evidence to the contrary, outside of the fact that there was a door on there. The plaintiff never suggested any of the witnesses from the defendant were not credible or lying or had an incentive to raise the water temperature. The testimony is the intent was to keep folks out to avoid this scenario, but right. We don't have 100% guarantee that it was ultimately successful in doing so. Again, this is not a high security system that was in place here. Keys were routinely changed out as employees were changed. There's no guarantee someone didn't leave the door unlocked when something else was being serviced. And everyone testified that they wouldn't have intentionally set this to 150. And again, this isn't digital. This is a fraction of an inch between 125 and 150. Someone could have bumped it when they were in there and it could move that fraction.
Right, but the trial judge, he was sitting as trier of fact, he's presented with two theories. One is the defendant or one of his employees went in there and accidentally or intentionally put it at 150. or some random person came around for reasons unknown, either broke in or went in there, somebody forgot to lock it, and set it at 150. So those are the two theories. And this is a civil trial. Which one seems more likely?
But Your Honor, I don't know that those are necessarily competing theories. I think plaintiff simply just presented the concept that it must have been one of the employees. It must have been one of these key folks that did this.
Right, but your client's saying it must have been some random unknown person who could have done it. Not did do it, but possibly did it.
And isn't the must-have analysis, isn't the purpose of the notice requirement to avoid this must-have analysis for a court to fill in the must-have before and after?
Well, there's circumstantial evidence that is relied on in a lot of cases, but we understand your point. But if you're right, this shouldn't even gone to trial. It should have been dismissed on summary judgment.
Correct, Your Honor. But at a minimum, I recognize the different burdens between summary judgment and trial. But our point here is that it is the plaintiff's burden to affirmatively prove the existence of negligence and, from our view, the existence of notice, and neither was done.
What about future damages?
Your Honor, I would submit that the future damages exceed what is reasonable, in large part because there's no objective basis for them. The plaintiff's treating physician testified she healed well approximately 6 weeks after the incident. She had no further treatment. That doctor hadn't even seen the plaintiff for nearly over 2 years at the time of trial. There was no medical evidence of any continuing treatment. The only testimony was continued itching, which was resolved by the application of cream. And I think even the plaintiff's doctor conceded that patients can describe itching as a practical effect of pain sensation. But at the end of the day, there's no doubting this was a significant incident. No one is attempting to minimize that on the appellant's side, but the records indicate she had a good result. She had a healed burn approximately 6 weeks later with no further treatment. And this just dovetails briefly into the records that were precluded argument as well. The plaintiff's medical history subsequent to her discharge would have made clear that she had a lot of overarching significant health issues that impacted her well-being.
And that's subject to an abuse of discretion standard.
Correct, Your Honor.
Got it.
Thank you.
Thank you.
Don Andrews versus JCP Groceries, Inc.
Good morning, Attorney James Alexander on behalf of the plaintiff appellant. It's respectfully submitted on this appeal that the trial court erred in dismissing this slip and fall case against the Big V supermarket.
Could you go right to the constructive notice, please?
Yes. The constructive notice is based upon a recurring condition. The facts of this case were essentially the same as the facts in the Padula case decided by the Third Department 31 years ago, which has been the law for that department for the past 3 decades.
But Padula, in that case, did that involve shopping carts?
It did.
Okay, but it's seeing, I think, a little difference between the two is that the shopping carts in that case were routinely outside and brought in, or they're wet or snow or tracking in. Here we're dealing with a motorized car.
Correct. Correct, but I don't think that difference makes a difference in the application of the law. They're inviting the public in, they're using their instruments, their carts and electric carts to go out in inclement weather. It had been raining for 2+ days
But
there.
wasn't it a non-employee that was driving this cart?
It was. But the liability rests upon the supermarket for not drying the carts and having the runner carpet in front of the door, which was their regular safety practice. And yet there's no explanation for why on this day, with inclement weather and sloppy conditions outside, why it wasn't in front of the door.
Right. It was inexplicably put up against the beverage, stack of beverages, but if there's a recurring condition, if this is a recurring condition case, does that obviate the need? Does the visible and apparent element, is that irrelevant?
Yes, I believe that it is, given these circumstances of the imputed knowledge to the supermarket that patrons will walk in and bring water, carts will bring water, and electric carts will bring water, and the failure to adhere to their own safety standard of keeping the carpet in front of the door was a proximate cause of the accident.
Because if you have to prove visible and apparent for constructive notice, having watched that video, it's a pretty clear video as far
Yes.
as surveillance video goes. And it's a white floor, but you can't see any water on there. I can't see any water on there. It doesn't appear to be visible and apparent. A lot of people walked through it before the accident, didn't see it, didn't slip. So if you've got to prove visible and apparent, that's a problem for you on constructive notice.
I don't believe with a recurring condition that you have to prove that.
That's why I
Judge.
asked. So, all right, so
Yeah.
you're not relying on visible and apparent?
No.
For a sufficient, and if it's for a sufficient period of time, you got a problem too.
Yes,
Because it's
that's
only
correct.
2 minutes and 30-something seconds.
Correct. And that's why we submit that Padula is right on point, because it's a recurring condition, and because they actually created the condition as well. There's another basis which makes notice irrelevant, which is they let their instruments go out into inclement weather and bring the water in. Jury's certainly entitled to impute that they know that patrons and their carts are bringing water in, and that's why they have a safety measure of keeping a carpet in front of the door, which inexplicably was not placed in front of the
Do we know
door.
for sure, though, that that motorized cart, the gentleman that came in a couple of minutes earlier and parked it against the wall, we don't know that the water upon which the plaintiff slipped came from that cart?
No, I think that's a jury question to be decided. We know from other evidence that the husband testified that there was water on the floor, that there's an accident report by the store's employee saying that it was water on the floor brought in.
You can see him mopping it up, somebody's with the paper towels, but where did it come from and how long was it there?
Yeah.
We don't know if it was that motorized scooter. It could have been somebody tracked it in much earlier.
We don't have conclusive proof of that, Judge, but we do know that motorized scooter is a four-wheeled, rubber-wheeled vehicle that comes right in 1 minute beforehand and traverses.
The strength of your argument is this is summary judgment motion.
Yes.
You know, and so the standard we're looking at is what we have before us.
Yes.
So it's something to establish a trial. And I think obviously the strength of your case is the constructive notice, not the actual or creation.
Well, Padula accepted both arguments and said the jury should be charged with both
We
arguments.
understand that, but that's why the first question is about the constructive notice.
Okay.
Thank you.
Morning, Your Honors. Michael Pretsch on behalf of the respondent in this case. I believe when we see these store rainwater cases, we kind of see them fall into two separate groups. You have this general awareness of the potential of moisture line of case law where the courts have said, you know, that's insufficient to establish notice. And then you have these cases where, like Padula, where there are sort of gradual buildups of moisture. And just to quote Padula quickly, it says a reasonable inference could be drawn that water was accumulated gradually by multiple dripping carts and from customers' footwear. I don't think that that is the situation that we have here.
Padula is definitely distinguishable.
You seem to be arguing, at least from my understanding, arguing the fact that you put in some proof that they tell people to walk around if they see something that's dangerous or water. But what do you have in the record? Did any scheduling whatsoever that somebody specifically walked over that area? A lot of these cases we have, there's records that their store policy is, and every 20 minutes they have somebody walk through the store, check certain things.
So, Your Honor, in this specific case, we don't have a strict schedule like where someone signed off that I came through on this, but we do have testimony that someone would have come through at least every 30 minutes and remedied anything. And I didn't really talk about this in my my brief, but I think that the nature of the condition alleged is actually, if we're getting past sort of the notice issue and to the did my client act reasonably in light of the potential of this issue, which the lower court ruled on and said that they did act reasonably. The nature of the condition is actually proof that the defendant did take reasonable precautions to remedy any potential wet condition. The condition complained of is not this big wet puddle that is allegedly created over a long period of time. It's this quick sprinkle that apparently came off of a cart, maybe. As Justice Lindley noted, you see other people walk by. People don't seem to be aware of any wet condition, and I think that that's proof that my client did take these reasonable precautions that they specifically said that they did.
The most reasonable and easy precaution that could have been taken wasn't, and that's to put a rug or a carpet down upon where people enter, and there was none.
I think that there was a mat a few feet away from the entrance. I understand.
But it
Wait,
wasn't helpful.
I watched that video to see how many people came in and how many went over that rug. It wasn't in line. If you're going out of the store, maybe, not on the way in. And it would have been a simple thing to just drag it over. People aren't taking water from inside outside. They're bringing it from outside inside, and they had the carpet in the wrong place. It was an easy move, obvious move that almost every store does. It wasn't taken here.
I certainly can appreciate that point, Your Honor. I would just say to that end that the case law doesn't describe any one particular reasonable action that a store must take. It just
What
says
other
that-
reasonable precautions did they take to prevent, it's raining outside, to prevent water from being tracked in and causing a slipping? What else did they do?
They had periodic inspection of the front entrance, and if there was any...
If someone happened to be walking by.
If someone happened to be walking by, which the unrefuted testimony is would happen at least every 30 minutes. And again, I think the nature of the condition, that it was just a minimal amount of water, is proof that that was working, and it didn't exist for very long. There really couldn't have been
We'll look
anything.
at that. Thank you.
Thank you.
Williamsville Residents versus Village of Williamsville Planning Board. You're solo, Mr. Hopkins.
Oh, I don't see a call to council.
That's what I just said, you're solo.
Good morning, Your Honors. Sean Hopkins on behalf of People, Inc. and Bloker Homes, Inc. Because we submitted a joint brief, I'm also here representing the Village of Williamsville Planning and Architectural Review Board with respect to oral arguments. This involves
We know the facts, Mr. Hopkins, I'm sure you know.
Yes.
You would say that the village here gave us a hard look. They issued a 31-page negative deck, right?
I would.
And they covered the various aspects that are required with respect to parts 2 and 3 in the negative deck. The technical violation under type 1 versus unlisted, which occurred as of May of whatever the year was.
May 18th, 2020.
Right, so you would then rely on our cases that say, you know, you went through all the other substantive and you gave it a hard look. And I think Mr. Romanowski might have been counsel one of those two cases
He
for
was.
Walmart, as I recall. So what else is there to this appeal?
So there's only-
I don't mean to talk over you.
Thank you very, very much for summarizing our position. We do want to affirm. I just want to make one point clear in response to Justin Kern's comments. It is our position, first and foremost, that this is not a type 1 action. The reason for...
But whether or not.
But even assuming it is, right, we make it quite clear. You go to the 2 Walmart cases from 2009, and clear as day, the record demonstrates, number 1, identified the relevant areas of environmental concern. Number 2, took a very, very, very thorough, hard look at those. And then finally, Justice Kern referenced that 31-page negative declaration. As such, we think the secret determination issuing a negative declaration should stand. They also do challenge architectural and site plan approval. Again, the same deferential standard of review applies. You have the 2007 case from this court saying it's not your job to substitute your decision for the decision of the planning board. So yes, we would ask that you affirm the decision. Thank you.
Thank you.
Have a great day.
You too. Robert DiGecchio versus Grinnell Island Chapel.
Good morning, Your Honors. If it pleases the court, Gregory Erickson on behalf of the appellant, Robert DiGecchio. This appeal is about a motion.
Abuse of discretion. It's whether or not the court should have courts are supposed to freely grant amendments, and whether or not the court abuses discretion, and you feel that your position is that the court used the wrong standard and when the court found it was meritless. As we know that the court doesn't look at the merits or the legal sufficiency when it's examining a.
Yes, Your Honor. Thank you. That is our position. I would only add to that, we do have a law of the case argument that has to do with the 2018 motion for summary judgment from the same Supreme Court. In that motion, the decision that was issued by the Supreme Court recognized the plaintiff's riparian rights to the parcel of land that is at issue here. That would indicate a couple of things. One, that the proposed new cause of action for slander of title is entirely consistent with the prior law of the case. Also, that the plaintiff had every right to rely on that acknowledgement of his rights and the representation by the Supreme Court in the 2018 motion for summary judgment. The plaintiff should have been able to rely on that when briefing this case, when briefing the motion to amend the complaint, and that the merits of the proposed new cause of action were not fully briefed, which is an additional reason why the Supreme Court should not have examined the merits in such detail, in addition to the argumentation that Justice Centra just cited.
Thank you.
If there are no further questions, thank you for your time.
Matthew Burns versus Jennifer Grandjean.
May it please the court, Michael
Mr.
Steinberg.
Steinberg, right off the bat, what's the most important thing that was missing in this case?
It's hard to choose, Your Honor. For one thing, what's missing is the voice of the children.
A best interest inquiry?
That is one of the original sins in this case, is there was no best interest hearing.
Ever, throughout any of it?
Ever. And in fact, the fact that there was no best interest hearing plays into one of the fundamental errors that runs through this, which is the children were given no voice. Because of that, it was plausible, perhaps, for Acting Justice Dollinger to say that all of this was caused by Jennifer Grandjean's explicit, deliberate plot to undermine Matthew Burns as the father of the children.
But again, because the children never had a voice.
The children never had a...
would not listen to the attorney for the child.
Exactly. And the children had made it clear the way it is clear from the proof. There is no proof to the contrary that this started when Mr. Burns decided that he would no longer live by the agreement that he'd struck with the children in April of 2019 that made room for their obsession with soccer.
So wait a second, agreement with the children can countermand the agreement between the parents?
It does not, Your Honor, but it would have been one of the things that comes into play in a best interest hearing. These are your older children. They're articulate.
As we began,
yeah.
If there had been any best interest inquiry into any of these issues.
Did the court commit error when it cut off child support? I mean, isn't that the best remedy? Would your argument be that's the best remedy here? That just cut off, if the judge really believed after a best interest hearing, which, you're saying didn't happen, and it didn't happen, but would the remedy then be to cut off child support? That's an appropriate remedy under the law if the court got there after doing a best interest hearing, correct?
Well, the best interest hearing, Your Honor, would have been to look at what...
I know what, forgive me, I'm focused on a twig, because I know there's an issue here about the court allowed the father to terminate child support.
Yes.
All right? And it did so without having a best interest hearing.
It did so without having a hearing into the question of whether there was a lack of visitation caused by deliberate acts of the mother. And that's a completely different issue, Your Honor. A best interest hearing would just have decided if there was a basis for expanding visitation over and above.
It seemed like Justice Dollinger, on the father's request for more visitation, in the separation agreement, it said if he moves closer, he can petition for more time.
Yes.
So that obviates a need to establish change of circumstances. It doesn't mean he's automatically entitled to more visitation. It just gets his foot in the door, which he might not otherwise be. It sounded like what Justice Dallinger's interpretation of the agreement is the parties agreed if he moves closer, he gets the visitation. When it plainly says if he moves closer, he can petition for more, and the court still has to make a best interest determination, whether it be by hearing or otherwise. But as far as child support, that's a separate analysis, is did the mother deliberately frustrate the father's visitation rights? But, I mean, what permeates this case, and I can understand Justice Dallinger's frustration, I understand the father's frustration, is what can a court do when there's evidence of alienation? And I know you don't think there is any, the mother denies any. My reading of it was the children's refusal. The father was just asking for an extra overnight he was getting in Friday till 6:30 and he wanted just to Monday morning. It was not a big deal. The kids come up with, well, all the excuses, none of them seem genuine to me. We got to do homework. On Sunday night, you're waiting till Sunday night to do homework, and they can't do homework at their father's house. And then there are other complaints where, well, he doesn't cook for us. We have to go out to restaurants again. I mean, these are little boys. They're objecting to being taken out to a restaurant for dinner. None of them, come on. None of them seem legitimate. So I share the frustration of the father and the suspicions of Justice Dallinger that the mother was influencing them. But the question is what to do about that. And I don't think there's any good answers to that problem. I experienced as a trial court. Do you lock the mother up or the father if he's the one alienating? That's a really bad solution. Do you cut off child support? Less bad, but then you're hurting the kids because there's less money. What do you do there? Justice Dallinger came up with his answer of house rules, is that we're going to punish the kids for the mother's alienation. We're going to punish the kids. They can't have any cell phones, any electronic devices. They can't visit their relatives. They can't go to their grandparents' house. They can't visit friends. They can't do anything but go to school and church. These draconian house arrest rules were his answer to that. And I don't think there's ever been a court who has imposed such rules anywhere in the United States. It's an issue of first impression here. There are cases where courts approved parents imposing house rules, imposed by the parents. That's different. This is the court imposing them at the father's request. So that's really the issue on that. But I do think it's on the surface, most people look at it and be like, this is an easy reversal. You can't have those house rules. But there is a huge problem there, and I think that Judge Dallinger was trying to solve it, is what to do in these situations when somebody's being deprived of visitation unjustly.
Well, Your Honor, this really gets into the heart of the case in a different way. I do not think that you can look at this record and find actual evidence of parental alienation on the part of Jennifer Granchi. However, that aside, if you look at the chronology, in January 15th, Mr. Burns brings his order to show cause. By March 15th, only 2 months after, he's asking the court to impose these house rules, which the court had actually mentioned a couple of weeks beforehand. There was no opportunity here. The court gave the children no opportunity to speak, and the court gave no opportunity to this family to work together to find what a proper visitation regime would be in the best interest of the children. Instead,
again,
and
we may be in a different situation had there been a best interest hearing at some point, or a Lincoln hearing, something.
Exactly.
But this was never addressed.
It was never addressed, and what happened instead was, in violation of a principle which goes back almost 100 years to people ex rel Sisson, no end of difficulties would arise should judges try to tell parents how to bring up their children, the Court of Appeals said. It was prophetic. Look at what happened here. Everything that was done.
We understand that. We've been through this and been through it and been through it. But again, we may be in a different situation had any of this inquiry been done. If any of the best interest inquiries been done, we might be in a different position. But at this point, we don't have that.
Yes, exactly. What happened, what destroyed,
what happened.
What destroyed this relationship was turning it into a power struggle.
Okay, we don't have to go into all that.
Okay.
What
If
about
the
the
house-
contempt?
Contempt. Well, for one thing, if contempt is violation of the House rules and the House rules are ultra vires, there's no contempt. Because there is an exception. And yes, you have to obey valid, though incorrect, orders of the court. But if the court has no authority to act in this way, if the court has stepped beyond its powers, which is stepped inside the threshold of the House in this case, there should be no contempt for violating them. It was as well, and contempt has to be a deliberate act which prejudices the rights of the other party.
The violations here, remind me, this is a huge record, but she allowed them, or the kids, in violation of the House rules, at one instance played a game on their phones called Battle Royale or something? Clash of
Royale,
Royals?
yeah.
Yeah, Clash of something. The other violation is she allowed her mother to sign the kids up for soccer.
Mm-hmm.
And the grandmother came over to help with math. The grandmother, former math. These are the things she's going to be locked up for, I believe.
And they don't prejudice Mr. Burns. The soccer thing is always very strange to me because it was because the grandmother did the initial registration for the kids that they did participate in soccer and they did see their father. I don't see how his rights were prejudiced when actually what they were doing was using the carrot that was in the carrot and stick system that Judge Dollinger had set up. And visitation resulted directly from this violation.
He said his greatest joy in life is watching those kids play soccer. But the father's point is not is that the kids, somebody has to tell these kids that they don't make the rules, or as Justice Dollinger said, they don't drive the bus, and they can't decide when they're going to see their father or not. So he was putting his foot down. Justice Dollinger was putting his foot down, and the kids can't drive the bus. It sounded like neither parent, it was Justice Dollinger in the driver's seat of that bus. But that was, I think, the father's motivation here. I mean, he was punishing himself, too, because soccer was his joy. But he thought it was important that these kids be taught a lesson that they are children, we're adults, they don't make the rules.
He was punishing them by taking the doors from the house, from their bedrooms. He was punishing them by taking all the food out of the house. He wanted them kept in their rooms 24 hours a day. This is self-defeating.
Again, you need to listen to the court.
I'm sorry.
Okay. We understand all that.
Okay.
And your time's almost up, so why don't you kind of wrap up the point you want to make?
I think one of the important things, especially Judge Lindley, is the Dwyer versus De La Torre case, which says basically, if the father had listened to the children and worked something out, he wouldn't have had this alienation. Children need to be listened to. They don't get to drive the bus, but family life is not about driving the bus. Family life is about learning from each other and listening to each other.
You don't need a lecture on that. Okay.
As far as, the cross appeal shows that what Mr. Burns' idea of how to deal with the problems of this family is actually just to make them worse, to have even longer incarceration and more penalties. This case has been a tragedy for everybody, but it's hurt these children most of all.
Thank you very much. Mr. Fronti?
Yes, good morning. Please the court. Let's address the evidentiary hearing issue first, and then perhaps go to the House rules. I submit under this agreement, there was no specific obligation that the parties actually had to have a best interest hearing. You have an exacting agreement under this case. You have situations
It certainly gave the father the right to petition without having to show any change of circumstances. We all agree with that. However, this case is just replete with instances where there should have been a best interest hearing, a Lincoln hearing, a best interest hearing, and none of that was done. In all this time period, none of that was done. It was asked for, nobody got it. The judge totally refused to listen to what the attorney for the child was trying to do, or any kind of advocation for the children, was just summarily dismissed.
So you have to break that down in 2 points, Judge. You have the visitation aspect and you have the contempt aspect. Surely in the contempt aspect, again, I just want to be clear, when you talk about repeatedly asked, because there's a lot of references in my opposing counsel's brief about AFC repeatedly asking, almost all those references take place during the trial. That's all in the context of the contempt hearing, and we know when we got to the end of that hearing in March, AFC said, I don't want to have it. I want to withdraw my request for a best interest hearing.
I don't disagree, that did happen.
So that happened. Mom continued to say, hey, I want to have a hearing anyways.
Right.
And then we got into the issue of, can we really have a best interest or a Lincoln hearing under the circumstances? We have procedural issues, right to confrontation, all those complications that came in as part of this. AFC having control over a best interest Lincoln hearing. I could only submit questions. And the judge said, no, I'm not going to have it under those circumstances. And we know Lincoln hearing, not adversarial. Now it's an adversarial situation. How do I cross-examine these kids as part of this sealed record? All those complications. So that's one issue. As it relates to the visitation aspect, decision made, I think it's the May 28th decision or so, right around there, up there, what information had been provided. So the analysis became, yes, my client's got his foot in the door. This agreement doesn't say after a hearing, and we could have put that in. I bet you've never seen an agreement that says what we do for Christmas when we believe in Santa Claus and when we don't. That's how exacting we got in this agreement. But Mom could have asked for that, didn't happen.
So your argument is that the Downer didn't have to have a best interest hearing, he had to make a best interest
Determination.
Yeah, he had to analyze the issue and make a determination on it.
Exactly right. I mean, nobody is entitled to a best interest hearing. Again, we all know that.
Wait just a minute. But just as Judge Lindy expressed, there's been no determination throughout this entire record, even by Judge Dollinger, as to the best interests of the children. That has never been addressed in all of these proceedings.
He has analyzed the information that was provided to him on the pleadings, on the initial application, as well as the motion to re-argue, and went through them as required by SL and determined them and said, what else would I possibly need? And he considered as part of this to say, what was Dad looking for? Dad didn't come in and say, I want a week on, a week off with 3 kids under 5. He said, I'd like an extra 14 hours every other Sunday, please, and I will get them to school because I changed my diet.
Right. It was a very modest and reasonable request that was unreasonably refused to be complied with by either the mother or the kids. I agree with you on that. But would you agree with me that to modify custody, the court can't modify without a hearing?
Judge, it wasn't custody. It was visitation. Again, I think that's another piece to consider under SL.
I was going to the influence zones, which is custodial related.
Sure, you're talking about the change in zones of interest now at the time of the trial.
Yeah.
So you know, as part of the application part of the many applications, we asked for a change of custody that was denied by Justice Dollinger. But what he did after a hearing and after everybody was on notice as to what my client was looking for, i.e. custody, that he, instead of giving custody, he gave an award of sole custody, the zones of influence. I think that under the circumstances and the cases that say, hey, if you ask for something that's substantially similar, there's no prejudice, you can award that. I think that was proper in this case. I mean, and again, just going back to whether a hearing should have taken place before that change to give my client that little extra smidgen of time. If you go back to SL, what are they concerned with? A high risk associated with determining best interest on a long-term basis. Now, in a custody case, we got a visitation case, we've got lower risk because of what the amount of time that he was looking for. This case would be different, Justice Smith, if my client was looking for that 50-50 shared custody. I would agree with that, but
this
that
case
wasn't
would be different in a lot of ways, but it is what it is.
But back to, you had an AFC that came in.
How many years have these kids been subjected to these house rules?
Well, Judge, The House rules came into effect around February, but here's the beauty about the House rules, because back to
There's
this.
no beauty about the House.
Judge, there's got to be some remedy for this situation.
I don't disagree with that.
Nobody's offered a suggestion other than Justice Dallinger as part of this case, okay? And everybody, my opponents want to say they're lasting forever and forever. But what do you do? Child support, and suspend child support, imperfect remedy, difficult to prove because you got to have intentional interference, deliberate frustration. I think we have that. Contempt, not a great result either. Nothing, everybody throws their hands up.
But that's what usually happens, is the person who has been alienated against just sucks it up and doesn't see the kids. That's what usually happens.
Exactly right, but with the House rules, a judge can come in, look at what the circumstances are.
Punish the children.
I wouldn't say they're punishing they're giving the children an incentive, Judge, is what I would say, to come visit. They're
You're saying
violating.
it's a carrot. Could end up a stick, but you're saying it was intended as a carrot.
Yes, and the beauty here is, the kids get a get out of jail free card, Justice Winslow, every visitation cycle. Would you want to come visit? These kids said, no, I'm going to take the punishment, is what they've said repeatedly. I'm not going to visit. I'm going to take it. They had the chance every single solitary time to come in and say, I'm going to come visit. Guess what? They visited Tuesday to Monday. They're visiting again tonight. These rules can work as part of this. Back to the issue about whether or not there should be a change or should have had a hearing on this in terms of that little bit of an extra time. You have 2 years of history associated with this case where these kids have visited at various points in time, at least 2 of them, the older, on the Friday to the Monday. You've seen all the papers. There's 17 motions, 18 motions.
Oh, we're aware.
You won't find in there a claim that says Dad didn't get the kids to school on time, they had problems getting their instruments, that they needed extra help. All Mom had was speculation at the time that she made that application or opposed my client's request. It's all standard things that you as trial court judges would see if you sat there in family court and say, my kids are used to a routine.
Okay, we'll look at all that.
Understood.
Last question for me, at least, is this: we looked at the House rules in Ritchie versus Ritchie a couple of years ago, actually last year, and it was we could have written it more clearly. I think you would agree with that, but I think a reasonable ruling is, a reasonable interpretation of our ruling is that we said a court has no legal basis to impose those rules. What would you say to that interpretation?
Judge, I think that you do. I mean, quite frankly, we know that under Roe v. Doe, parents can impose certain rules. And this is merely an extension of the unfortunate situation where my client's trying to impose some rules. I mean, look what you have here. The claim is good,
Right,
kids.
so we were wrong in Ritchie then. Wouldn't be the first time, but we were wrong in Ritchie.
Well, Judge, in Ritchie, I think as I recall Ritchie, that was a sua sponte application.
Right, but our decision says...
Right, I think was part of
Why
this.
don't you listen?
Yeah, our decision, the sentence says, no party requested such relief, home rules, because it was sua sponte, comma, and the court had no legal basis by which to grant it. Those are 2 separate concepts, so it was bad for 2 reasons. It was sua sponte, and in any event, the court had no legal basis to do it. That seems to be, I think there were 3 of us from this court that were on Ritchie, but that's a case that we didn't give a lot of explanation there, but that might be a case you have to overcome, or we might have to disavow it if we go your way.
Understood, Your Honor.
Okay, do you have anything further?
I would say, Judge, that the child support suspension was warranted on these facts because at the time that that application was made, you already had Mom denying that visit on January 2nd because kids wouldn't have a home-cooked meal. You had the issue on denying the visit on March 18th when her mom came out and said we got to wait for an AFC to get involved. You already had Mom having her mother and family over. So there are multiple violations that had occurred prior to that time, which would lead you to conclude that there already was deliberate frustration and intentional interference. And thank you for your time.
Thank you. Would you agree that these children need to be heard?
I would agree that these children need to be heard, and a Lincoln hearing should have been scheduled. I look at this almost like the way that the father is proceeding in this, that my clients are property, and if they don't follow a rule, then he gets to take his chattel in one way or another, even if it violates their human rights. In answer to Justice Lindley, in posing the question, what do we do? I mean, sometimes it's difficult to figure what we do, but what I do know is what we don't do is what was done in imposing these punitive House rules that are so invasive and enduring. Counsel for the father stated, well, it's only a couple of years. The couple of years of these children's life stays with them and lasts forever. So I would agree with Justice Lindley that it can be appropriate to establish House rules that are going to be positive, aspirational, maybe protective of the kids in certain aspects. But these are nothing but really destroying basic fundamental rights that they have: the right to play and engage in recreational activities, the right to their normal, usual social and emotional development, their freedom of association, the freedom to be free from any type of mental violence. And I do respectfully disagree that the father did not play a big role in the reason why the children are reluctant to visit. Certainly, just to begin with, when they started this whole visitation, taking the doors off isn't so invasive of a right to privacy of adolescents and teens. And then he proceeded later on. It's not a matter that they refused to go to dinner, but he said, right in the midst of a pandemic, you are getting out of the car, you're going to have dinner with us, and you do not wear a mask.
Well, one of them worked at a restaurant, did he not?
Go ahead.
One of the kids worked at a restaurant, or
For a short period of time.
Not at the time during the pandemic, but he did at one point do that. That's another thing, Your Honor, that you bring up that's a good point. My clients really just want to do usual things that most parents would applaud. They want to work and make money for themselves and learn responsibility. They want to engage in sports and be part of a team and be part of a community.
Well, let me ask you this. What if, let's assume that the children unreasonably refuse to visit the father, don't have any good reason. They just refuse to do it for no good reason. And the mother doesn't discipline them or take any steps to ensure that they visit their father. What would you have Justice Dollinger do in that situation? Incarcerate the mother? That's a bad option. That's going to make things worse.
Sure it is, because they only feel secure with their mother.
Terminate child support's a bad option, because that's supposed to go to the children. And so what would you suggest Justice Dollinger do in that situation if the children unreasonably say, no, we're not doing it. We're in charge here. We're going when we want to go. What's he supposed to do?
Well, I mean, the fact of the matter is, I would disagree that those are the facts in this case. But
I understand you disagree.
Right.
Let's assume they are.
But let's assume they are. That's one of the reasons why just short-circuiting and not having an evidentiary hearing and listening to the children was such a bad idea, number one. Number two, cutting out for what their own attorney could do. I can understand why the dad's attorney didn't want the AFC to provide information to the children because it might affect the case, because that's what the dad's attorney did with the dad. He had him, more and more, including this 24/7, kids stay in the room if you don't visit dad type of thing.
But again,
so he was
what's the remedy in that situation?
Well, what I'm suggesting is that if the attorney for the child was able to properly, speak with the children and figure out the problems, there could have been a whole best interest hearing.
My question assumes the children will refuse to go unless it's on their own terms, when they want, how they want, which happens. So again, I'm not hearing any other alternatives other than incarcerating, terminating child support, or house rules. Dollinger chose house rules. You don't like the other two. Is there an alternative?
I don't know how the house rules even gets into the same equation, because I don't think you can ever say these house rules, these punitive house rules, are part of a best interest equation, and that's the standard
The
court has
option
to follow.
is to do what has been done, is nothing, and the father never sees his kids.
But that's not the way it works out in this situation. If we could have had a hearing and all the facts would have gotten out there and the position of my clients would have made clear, maybe we could have obviated the situation we're in. Because clearly it's not a situation where it's alienation on the part of the mother and the father there's no responsibility on the part of the father. Every time my clients go over there, he has these basic rules. For example, you just have to say one word. That's enough communication. So he's making the whole situation miserable for them. Recently, this last week, he said, it's not just the house rules, by the way. I have zone of influence. That means I can decide, even if you come visit me all the time, I don't want you to sign up for soccer, and that's what I'm going to do. You're not going to get to sign up for soccer because I say so. That's the situation that's come of these rules. I think there could be a compromise, certainly something short of these punitive house rules, but there could be other ones, expectations that the judge could lay out that would be reasonable behavioral expectations of the children at both households.
I guess the point is that it's just amazing that it came to this tragedy based on the father's modest request, hey, can they just stay over every other Sunday night and I'll bring them to school on Monday. That's what prompted all this. It's amazing to me that we're here where we are now based on that little minor reasonable request.
That's not what prompted it, though. What prompted it is that issue. First of all, I do think I have to state on behalf of the children. Children too often have too many expectations. You know, you have to go to school, you have to join clubs, you have to do music, you have to do sports, you have to do all of these. Then you have to get your homework done too and do well at that. That's really hard to do on a Wednesday night. It's next to impossible. So I don't think we should say that my clients' requests are unreasonable. They certainly said, it would be unreasonable if they said, we're never going to visit Dad during the week. They said, no, it's just we can't do that in soccer. It ends at like 8 o'clock or 8:30. Other times we will do that.
I was talking about Sunday night, but in any event.
Okay.
I understand.
I think we understand.
Okay. So the only other point that I'd really like to emphasize on that, again, is I think it's a dangerous practice to cut down in an order how an attorney for a child can relate to their clients. It's very important. They're one of 3 attorneys. They have to live by all the same rules. I understand that there could be a certain paternalistic element. There could be a certain different element. For example, in the case cited by the father's attorney, there could be a narrow exception, but there can't be this broad prohibition of discussing issues with your clients.
Thank you.
Thank you, Your Honors.
Daniel Ryan versus Capitol Heat, Inc.
Perhaps we needed a moment of fresh air on that. I'm Robert Radel. I'm counsel for the defendant appellant, Capitol Heat, Inc. This is an appeal from an order denying summary judgment. We are relying on the case of Richards Conditioning Corp., which we believe is dispositive of this matter. The Court of Appeals in Richards Conditioning applied a two-step approach, that being, what is the purpose of the statute, and was the person licensed?
Who do you think the statutes were intended to protect?
To protect the public health and safety. The best looking of that is the statute themselves. When we look at the statute, it says the statutes were enacted for the public health and safety of the citizenship.
To protect people in their homes from being solicited by unscrupulous salespeople.
Absolutely. I think the best example of that was the town of Alden, which not only talks about, or the village rather of Alden, that talks not only that it's to protect the public health and safety, but it also for, and I quote, illegitimate solicitation practices of harassment, nuisance, theft, deceit, or troublesome or unlawful activities.
So it's designed to prevent homeowners from people coming to their house trying to sell things. Your client is not in that class of protected persons. Your client is a business that hires a salesperson to go to the people's houses. That wouldn't seem like a sophisticated business entity that hires salespeople to go to the houses is in the class of people thought to be protected by the peddler's licenses statutes.
The peddler statutes, though, are for the public health and safety, and it is when that peddler goes and fails to go through the vetting process, fails to do the background search, and then that person goes to the people's houses. That's where the harm to the public comes about. What is my client left with? Do I stay in a relationship in which I know that they are not getting licenses, I know what they are violating the peddling statutes, the very peddling statutes that were enacted for the public health and safety, or do we say, I'm not going to be involved in that illegitimate business?
That's a really good point. But there's a distinction between saying, I'm not doing business with you anymore because you don't have licenses. That's one thing. It's different than what's going on here is saying, I'm not paying you for all those furnaces that you sold. I'm not paying your commission for the furnaces that you sold. Aren't those two separate things? One is going forward, I'm not doing business with you anymore. We have a contract, but you don't have licenses. Yet now he's looking back and saying, well, you sold all those furnaces to these homeowners. I'm not paying you because you didn't have a license. Those are different.
Yes and no, Your Honor, because that goes to the sword and the shield argument. And the issue is, we paid Ryan. Capital Heat paid the plaintiff Ryan in full for every furnace that was installed. That is set forth in our brief. It is set forth.
That's what they're suing you for, though.
No, they're suing me for future damages as well on the second cause of
I agree,
action.
future damage is different, but they're suing you for unpaid installations.
Correct, and in their brief, they indicate that there was 155 furnace contracts that were obtained and installed. We pay $1,100 for each furnace contract that results in an installation. That comes out to a total, and it's in paragraph 3, or page 3 rather, of the plaintiff's brief. You add to do the math on 155 times 1,100 is $170,500 that is owed. However, page 3 of their brief also indicates that Capital Heat paid $177,300. We actually overpaid $6,800. If the court were to apply the Thistle analysis, saying, okay, what is the balance of the equities here? Who's being hurt? We were involved in a relationship in which they weren't getting peddling license. We found out that they weren't getting peddling license. We said we're not going to be a part of that, but they've been paid in full for the services they perform.
You're saying that the plaintiffs have been paid in full, these sales people have been paid in full for every single furnace that they sold on your client's behalf?
The arrangement was that they get paid for every furnace that gets installed.
Yeah, so you're saying that they've been paid for all those?
That is correct.
Well, maybe I misread the record, but
Yeah, maybe I did too.
I thought part of the problem was they were paid for what they've installed, but there's other contracts that they haven't installed yet, that they're going to install, and that is the damages they're looking at. That's
No, sir.
no, okay.
No.
You're
There's
telling
a
me
total-
you're telling me the ones that were installed, there's no other outstanding contracts.
That is correct. There
So-
was to be clear, there was a total of 675 contracts. Okay, one of which was obtained with a valid peddling license in the town of Kenmore after the plaintiff's independent contractor had gotten picked up by the police and cited for not having a peddling license. But there's one that was valid. Now, that brings to 674. Out of the 674 furnace contracts, only 155 got installed. Why was that? Because the remainder of them got canceled.
So you're talking,
70,
so
yeah,
500 or so, whatever.
77%.
There's no outstanding contracts that are presently in play that were obtained by the plaintiff in this.
That is correct. And the reason that the 77% cancellation rate is so important is because it goes to the very purpose that peddling statutes were enacted for, to stop illegitimate activities when they're sitting there making promises to people that aren't true. such as you'll get a free furnace, such as you don't have to pay for the furnace. Making these things, that's why there needed to be a vetting program. That's why the statutes, Town of Alden, for an example, says we run background searches on them. There's a vetting process on it. We're not going to let just anybody run around our town and do these types of things. When Capitol Heat learned of this, that's when we said, no, we're not going to be a part of it. Because what is my client's option then? If we apply the equities in Thistle, we sit there and we say, we shouldn't be a part of it. When I say we shouldn't be a part of it.
I think we have that argument. Do you have
Okay.
anything further?
There is Rosasco. Rosasco Creameries is a Court of Appeals case from 1937. It draws the distinction between a case enacted for the public health and safety and one that is not enacted for the public health
We
and safety.
understand that.
Thank you, Your Honor.
MTGLQ Investors LP versus Seema Zaveri.
Good morning. May it please the court, Virginia Grappenstetter, Friedman Bartolo for the appellant plaintiff. This involves a foreclosure action that was recommenced pursuant to CPLR 205A.
So we have to decide between a couple of dates, is what it comes down to, right?
Yes.
So if, and it may be the wrong language, but the trigger date under defendant's argument is March 2, 2017, that commences 6 months under 205A. Your argument is no, following Malay versus City of Syracuse. No, it's November 30, 2018 that triggers the 6 months, that we were timely within that 6 months.
That's correct.
And you would say we should follow Malay and be done with it?
Absolutely. That's the crux of our argument. That original dismissal that respondent is using, there was no order to appeal from. And so the plaintiff in that action was required to move to vacate that appeal in order, or vacate that order in order to appeal that dismissal, which they did. And that, you know, the termination of that action was when that appeal was ultimately dismissed by the court for failing to perfect.
But
And that's the crux of
Mr.
our
Rosenbaum argues that this is different than Malay in that there is no automatic right to appeal here. I think Malay was maybe a summary judgment case, if I'm not mistaken. So there was a right to appeal automatic. Here, it was a default, and that's why there was a motion to vacate the default, because you can't appeal otherwise. But, so there was no automatic right to appeal from that dismissal, and that's why this is different.
That's correct.
Procedurally.
Correct.
How do you respond to that one?
A plaintiff has the right to appeal that dismissal, and the only way they could do that was to move to vacate, which was done. They moved to vacate, the vacate was denied, and they moved to appeal.
Well, you didn't have to appeal, you could have just commenced a new action. That's his point, is that you didn't need to go through the motion to vacate and then appeal, and you, once it was marked off the calendar, you wait a year to the March 2nd, 2017 date, or even sooner, and just commence the new action. Wasn't done here inexplicably.
I don't think that changes the right to proceed in that manner, though. I think they're still entitled to proceed by moving to vacate that dismissal.
Just because you could have done one thing doesn't mean you can't do the other.
Right, it doesn't mean they were required to do that. They have the option to move to vacate that dismissal.
And one could argue that if you didn't do that, you might have two actions pending that would preclude the second one.
Correct, yes.
You know, he seems to be relying on the defendant Slavin, Justice Ahrens. He's making that very argument that lost in that case. And you're relying on the majority there. You feel better being in the majority than in the sole dissent.
Absolutely, I prefer the majority. Yes, I mean, we're considering Malay the controlling decision here. And not the case, I know he cited some cases that were older, but I would consider those overruled by Malay in that decision they're in.
Thank you.
Thank you.
Juan Rosenbaum for the defendant, respondent. Malay has nothing to do with this case, Your Honor.
Well, it has nothing to do with the case, but you spent 3 or 4 pages in your brief distinguishing it, and the best distinction you could come up with, as I understand it, was BAC Homes. There you said, hey, wait a second, BAC Homes, there they had an appealable order. Well, if you recall BAC Homes, it had both. It had an order that was entered upon the failure to file a motion that was reported in the foreclosure case. The court actually entered an order. That the, whatever department was, said, wait a second, that's not appealable because there was no notice in motion. But it still addressed the motion to vacate, which you didn't address in your brief in BSA Homes. That's what we have here. There was no order, right? There's just a marking off on the calendar. That's not an order.
You're not required to have an order under 3404. It's deemed automatically terminated.
Well, but that doesn't mean you can't go get yourself an appealable order. You're allowed to go get yourself an appealable order. You're not stuck with, gee, I have no right to appeal. There's nothing I can do. And you're not forced to commence another action. You can, correct, go and get an order vacating that deemed dismissal.
Why would, why?
I know I'm going on here, but give me a second.
Sorry.
I know it's not fair between us.
You're running the show. Go ahead.
Maybe not, but you're entitled to do what the plaintiff did here. Even if they could have done something else, they were entitled to do what they did here by moving to vacate, correct?
They could move to vacate. They could, and in fact, there's no time limit. They could wait 20 years to move to vacate.
Forget about the time frame, but once they move to vacate.
But we can't forget about the time period. We can't forget about the time period because that eliminates all certainty associated with statute of limitations in a foreclosure action. Then we have a never-ending foreclosures action. We've got there's no dispute that when 3404 came and went, that 1 year went and the case was marked off the calendar, that case was terminated. We've got the Tellison case, we got the Jelinek case.
But you recall both those cases applied the Civil Procedure or Civil Practice Act. It predated the CPLR. The second one, Jelinek, was after, but it applied the 1954 case under the CPA. The law under the CPA, Mr. Rosenbaum, was different. There, a deemed dismissal constituted an appealable order. Under the CPLR, that is clearly...
Oh, I agree with that, Your Honor. It's not...
Those cases don't count.
I agree, but I don't think the fact, whether it's an appealable order or not is irrelevant. The case was terminated after the 1 year was marked off the calendar.
But Millay says to the contrary.
No, I don't think so, Your Honor. I respectfully disagree with that. Millay is a different factual scenario. What happened here, Your Honor, is that the case was marked off the calendar.
So I can't understand why you didn't cite to Slavin or distinguish it once. As one of my fellow colleagues here, but hear me out, you didn't address it in your brief at all. Instead, you make all the same arguments that Justice Ahrens, in sole dissent, accepted. So why not distinguish it? Why not recognize that you're making the arguments in dissent? Why not tell us that?
I can do that, Your Honor. I can do that.
Well,
and
you had your chance in your brief. Why should we?
Well, I don't think I've waived any rights I have under the law, Your Honor, by not.
I'm not suggesting you do, Mr. Rosenbaum.
All I'm saying.
But you waived it. Wait a minute. Wait until Justice Carney.
I apologize.
But my question is not an easy one for you to answer. Can you tell me why in your brief you did not address a case that seems to be right on point here from the third department, the Slavin case, but instead you seem to make all the arguments accepted by the defense here? So two questions. First, why didn't you cite or distinguish or somehow address Slavin in some way, shape, or form? And do you agree that you are making the same arguments that Justice Ahrens used in dissent? Two questions.
Both good questions, Your Honor. To answer the question, the first question is why didn't I cite Slavin? I can't remember why I did something and didn't do something yesterday as opposed to 6 months ago. So I apologize for not being able to give you a straight answer, okay? I've been at this for 50 years, so sometimes my memory is not as good as it used to be. But nonetheless,
even almost 40, the same thing happens.
Okay, well, but given, there's no question that Slavin is a case that made new law in my view. It is not cited. It's never been followed in the first department. It's not been followed in the second department. It hasn't been followed in the Court of Appeals, and it's never been followed in this court. This court has got a different set of rules. I mean, this first and second department disagree with Slavin. And
expressly?
Well, no, Your Honor, they don't expressly, but you can't...
You have any, even after Slavin, that disagree with it in any way?
No, but you can't reconcile Slavin with these first and second department precedents. They're not reconcilable. You've got a termination of an action. I think Justice Lindley mentioned it. One of the first questions asked out of the box here of my opponent was, you were presented with an opportunity under 205A to commence a new action. There's no dispute opposing counsel does not dispute, when that action was dismissed under 3404 after 1 year, they could have commenced a new action. They didn't do that, okay? What they wanted to do was argue about whether their case should have been dismissed at all, and they wanted it reinstated. They wanted the default vacated. Why didn't they do that? They're asleep at the switcher, Your Honor. Anybody under reasonable circumstances, if they were knowing what was going on, they would have filed a new action. They wouldn't have waited until after the time had passed, okay, to start a new action and then move to vacate. The 6 months had already gone, the 6 months under 205 had already gone by. When does this process end?
If our court follows the 4-1 decision of Slavin, your position will be rejected, correct?
Well, I don't know, Your Honor. I don't know if the court is of a mind to do that.
I'm not suggesting we are, but if we did.
There's a distinction, Your Honor. There is a distinction, and I apologize for not mentioning it in my brief, but there is a distinction. In Slavin, there was an order entered. An order of dismissal was entered, and that's the one that they moved to vacate, okay?
So that makes that distinguishable from here?
Yeah, because in our case, there was no need for an order.
Mr. Roseman, that's also true, respectfully, sir, in BAC Homes, the case you rely on to distinguish Millay, all of which means that if you can't rely on BAC Homes, Millay is not distinguishable, and we have to apply it. It's court of appeals.
Frankly, I think, and I know that this court it's going to make up its own mind because there's no binding precedent for this court. But what do we do here if we follow Slavin in this case and apply it to these facts? What have we done? We've created a situation where there's no certainty because you can move to vacate a default. And you can move to vacate a default at any time. It's within the discretion of the court. 5515 does not set forth all the basis on which a motion to vacate is.
We don't have that case here, Mr. Rosenbaum. It's not 20 years later. It's within the year that they had a chance to move, et cetera. So we don't have that case. But you might have a stronger position if we had some hypothetical case 10 years from now where they wanted to use that 6-month extension because they waited in their hands and then they made a motion in the interests of substantial justice. But we don't have that here, correct?
I understand that, but if you rule like Slavin in this case, you're essentially giving license to that kind of result in the future, okay?
And we can deal with that then?
It's tough, Your Honor. We've seen cases where we box ourselves in on some rulings and we get into a situation where we get the more egregious facts and then we don't seem to be able to reconcile them anymore.
You're worried about the next case?
I'm worried about my client, but I'm also worried about the next case as well. But I just don't think that we need to have finality in commercial cases and mortgage foreclosure actions. And how is a title company, for example, what is the dilemma we're creating, for example, Judge Curran, for a title company when they have to issue a title policy knowing, well, this case was dismissed 10 years ago, but I can't write a title policy for this because anybody can make this motion at any time. There needs to be certainty in the law of foreclosures, and it applies not just to foreclosures, but to commercial law and contract law in general. We undermine the public policy behind statutes of limitation when we do things like this. I understand the desire to try to get somebody out of a jam here, and it's obviously, to me at least, that the counsel for the bank here, the lender, because it's not the bank anymore, it's somebody that bought a bunch of mortgages, to bail somebody out here, but this is not the way to do it. They had plenty of time if they were diligent to commence that action, and they failed to do it, and I don't think we should reward them for their lack of attention by giving them the basis, applying Slavin in this case. We would respectfully request that the court's decision below be affirmed. Thank you very much for your time this morning.
Chad Signakis, etc. versus Town of Cohocton, Town Board. Who's going?
May it please the court, Gary Abraham for the appellants. I'd like to ask for a point of clarification initially. Mr. Naughton filed a post-argument submission a week ago, and I filed my reply yesterday. His submission included an attached photograph, and my submission included an attached affidavit with exhibits, but the affidavit and exhibits were removed from the docket.
You filed the post-argument submission before argument?
Yes.
A pre-argument submission, if you will?
Well, I'm not sure what to call it. I was replying to Mr. Naughton's action, submitting his claim that this case is moot, and attaching an undated photograph showing them constructing the wind farm with their 650-foot turbines, which is the issue here.
I haven't seen that myself. But we'll take a look, yeah.
Well, my letter is in the docket. And
So
the
to me, we
support.
should be dealing with what is in front of us at
Yes,
this point.
because
Pardon me?
none of, this court has not seen that.
Okay.
So why don't we deal with what we're,
It looks like it came in on August 30th and September 6th. According to the record I just pulled up real quick, but it just hasn't worked its way to us.
yeah, so we have not seen it, so why
We'll
don't
look
you-
at it, right?
Okay.
Counsel, not to get you off your game, but I read your brief as saying one contention only, that the rule of necessity doesn't apply. Assuming we get over the threshold matters as you describe them in your brief.
Yes.
We have to look at the rule of necessity, whether or not that applies. You say it doesn't.
Right.
Okay. That's the sole contention, basically.
Well, that's the central contention, and I think if the rule of necessity does not apply, the tainting of the town board by a conflicted town supervisor affected the seeker determination. And all of the work on the seeker determination was done by the petitioner to the town, Barron Winds, for the amendment. They didn't do any of that work. The documentation for their environmental assessment form was provided by Jane Towner, the wife of the supervisor, being paid over $100,000 a year to advance the project with all of the local authorities for required approvals locally. So there isn't any dispute here among the parties, and the town is missing, I might note, that Supervisor Towner had a direct conflict of interest. The question is, should he have recused himself? And he didn't. The Zagorios 1985 case is very clear, and all of its progeny state that the test for an impermissible conflict of interest is whether it raises the appearance of corruption. And anyone who saw this process in the town, in fact, Supervisor Towner was turned out of office right after this vote, or actually before the vote. The November election came before the December 17, 2019 vote, which is some indication of the feeling of the voters about Mr. Towner's conduct. But there isn't really any dispute that his conduct was conflicted, and he should have
That's, we're going to
recused.
have to look at that.
Okay. The record also shows he was a member of the Steuben County IDA, and when the Barron Winds project came up before them, he abstained. Did not recuse, but at least acknowledged that he had a conflict. On the town board, he did not even do that.
We'll look at all that.
So our argument is simply that they failed to carry their 4-to-1 vote. They were required to have a 4-to-1 vote because the town planning board said the environmental assessment was not done and should have been done over, did not approve what the town board was doing, requiring a supermajority vote, 4-to-1. Mr. Towner's vote was that fourth vote, and because he acted illegally in voting, the town board did not obtain a supermajority vote, and the 2019 law is a nullity. The 2006 law providing for 500-foot turbines, which was working out just fine, by the way.
Is that your argument?
Yes. Thank you.
Thank you.
Good morning. Michael Norton on behalf of Barron Winds.
I apologize for the snafu with respect to the filing of a post-argument submission. I did personally call the clerk's office and asked how this would be done because there was a mootness issue, and I understand it's my obligation to inform the court if a matter becomes moot. The individual I talked to
Well,
said...
again, we don't have any of that in front of us, so why don't you?
So, okay. So what this letter says, it's a 2-page letter, it brings the court current with respect to the status of construction in this case. Our brief, which was filed in March of this year, indicated that by the time we would get to oral argument, this case would be moot because so much construction would be done at that point.
Is the construction completed?
It is not completed. It is 50% completed.
And it's moot because they've already expended so much money, they're raising the towers, and so it's too late to turn back.
That's correct, Your Honor. There are 32 turbines with respect to this project. 22 of them are in the town of Cohocton. All 32 foundations have been completed. These are enormous foundations to hold up.
Well, isn't that kind of risky to, when an appeal's pending, to spend all that money and assume you're going to win the appeal?
I don't believe it is under the law with respect to vested rights and mootness and when something becomes academic. The vested right doctrine says that when you have steel in the ground, steel and concrete in the ground, and you've spent $100 million on this project, you're entitled to vested rights.
So is your position in these letters, is your letter that this appeal is moot?
That's correct, Your Honor.
But you haven't moved to dismiss?
I did not make we argued this all along, and I checked with the clerk's office that it should not be done as a motion to dismiss for mootness.
Okay.
Okay. There are 200 construction workers on site as we speak. The materials have been delivered. These are very expensive machines.
We got all that. Why
Okay.
don't you argue what's in your brief?
That is in our brief. That's point 3 of our brief, that we would be at this stage at this point, and there was never any motion for a preliminary injunction to stop this project. Getting to the merits, one of the claims that has been raised relates to Section 810 of the town zoning law, which is the supermajority provision. It's our point that this is just also an academic point because we had a 4-to-1 vote, and if you take Mr. Towner out of that equation, it would still be a 3-to-1 vote. And that law says that if the planning board recommends on the referral of a local law, amending a zoning law, if they recommend disapproval or modification of the law, then you need a supermajority by the town board to approve that. The town board in this case relied on the official minutes of the planning board, which did not say that they disapproved the law, and it did not say that they recommended a modification of law. Instead, the only statement was that we think more seeker analysis should be done with respect to that law. So because a supermajority was not needed, all of these issues with respect to conflicts of interest also become academic.
Saying if Towner had voted the other way or abstained, the result's the same?
Correct. And that's why we have these conflict issues in the case. They're trying to get to a supermajority.
Don't you think it does create the appearance? Towner's wife works for Barron Winds, and
yes, I want to correct something on that, Your Honor. I just heard that Mr. Towner did nothing with respect to abstaining. Okay, 2 years prior to this vote, in December 17 of 2019, Mr. Towner expressed on the record when the HCA, the host community agreement, came up in this town, whether to support this project, he abstained. And he did so because he indicated that his wife was a consultant for the developer. And there are affidavits from every single town board member that was involved with this that they knew about this, including the supervisor at the time.
He didn't abstain on this vote?
He did not.
Why not?
Because he was advised by a town attorney Jeffrey Squires, who's a seasoned attorney, that the rule of necessity required that all 3 board members with potential conflicts vote on this so that there would be assured quorum for this vote. And the reason that this came up was because the anti-wind folks who opposed this project and others, including the CPP, which is the Canandaigua Power Partners case project, they all were going around. There's 4 different towns involved, and they were alleging conflicts. So the town board members knew that this was going to be an issue, and they needed to make sure they could have a quorum. So in connection with the CPP project, which is different than ours, different developers, and that was a repowering project, the question was asked, are we going to be able to vote? Are we going to have a quorum to be able to take action? And Mr. Squires got a research memo from Barclay Denman that discussed the rule of necessity in detail in all the case law.
Which said that even if you have an obvious conflict of interest, if we need you, you got to come vote, despite the fact that your wife works for a party.
That, it does not get to that point, Your Honor, in that memo. But Mr. Squires, it was written in connection with another issue in the town, which was the CPP project. So when it came time for this town board to take action with respect to this local law, Mr. Squires advised all of these board members, and this was done in public, that he should vote so that there would be a quorum. Because some of these other town board members, Ms. Dusenberry and Mr. Simola, were landowners that had contracts, leases, with another developer. So this would have been a situation in which the town board would have been unable to act. And so under the rule...
They would have been unable to act because Baron Wins had relationships with 3 other members.
No.
Had relationship with one of the members' wife.
Just one member's,
And
yes.
the other 2 had a vested thing, the other 2 board members stood to gain financially.
No, they did not. Because the CPP project was a repowering, and they were not going to go above the maximum limit because of the foundations, our old foundations. They took down the obsolete towers, blades, turbines, and we're going to put up new ones, and they've done that now. Those are up. So, so that's the reason that the question was asked, and we've got affidavits from these town board members, and you could see from those affidavits they took this issue very seriously, and they got legal advice before they
Petitioner's
acted.
contention below was that all 3 were conflicted, both.
That's correct, Your Honor. We've had a flip-flop on appeal.
And that was what was argued not only in the petition, but also to Supreme Court.
That's correct, Your Honor. In paragraphs 34 and 103 of the amended verified petition, the petitioners alleged that all 3 members had conflicts of interest. On appeal, they are presenting the argument that only Mr. Towner had a conflict of interest.
Okay.
It was not argued below, and I
understand
believe it's a new argument that should not be considered. There's also the question of estoppel against inconsistent positions. This conflict issue was aggressively pursued by the petitioners in other forums, and Mr. Ziegenfuss went to the trouble of getting a code, the local code board to issue a decision that said she could not be involved in any other decisions relating to windmills or wind projects. So she got a decision, he got a decision against her. It wasn't like the argument was made and nothing happened.
Anything further?
I just think that when you get to the disqualifying question of whether it was a conflict with Mr. Towner, I think that there's a lot of guidance from the Hosmer case, which was written by Judge Valentino, a former member of this court, I believe. And he did a very good analysis of what kinds of disqualifying conflicts should be considered to throw out a vote.
We don't have to get there if you're right that the only issue they're raising is not properly before us.
That's correct. That's
Thank
correct. Thank you.